Welcome back to Good Law, Bad Law. First of all, please excuse my cold, which has wrecked my voice. But much, much more importantly, we have a great episode with returning guest Steve Vladek. He is a professor of constitutional law at the University of Texas Law School, and we are talking about the Thanksgiving week battle royale between President Trump and Chief Justice Roberts over the legitimacy. Can you believe that we're actually talking about the legitimacy of the federal courts in our country? But that's really what's at issue. And Steve is not only an expert on this, but has really picked apart the president's arguments and claims regarding a dispute that stems from a decision in California in a federal court interpreting an asylum law with asylum seekers at our southern border as we speak. This is a great issue and a really important issue, and Steve's the perfect guest to work through it with us, so stay tuned. Welcome back to Good Law, Bad Law. My guest on today's episode is Steve Vladek. He's been a guest on the show before. So first of all, Steve, thank you very much for coming back to Good Law, Bad Law. I really appreciate it.
Happy to be back.
Steve is a professor of constitutional law at the University of Texas Law School. And there I was just after Thanksgiving down with my wife's family in Georgia, and I'm taking a look at my Twitter feed, and there is this string of tweets from you, Steve, about the battle. And I want to ask you as we get into this, first of all, is this unprecedented? This battle of words between President Trump and the Chief Justice of the Supreme Court, Justice Roberts, over this decision that went against President Trump on an issue relating to asylum, because it sure sounds absolutely crazy.
Yeah, I mean, I think it's certainly not a good look for most of the participants. Unprecedented, I think, is strong only in the sense that, if we rewind, 57 years to the beginning of the Civil War, President Lincoln got into some pretty heated battles with Chief Justice Roger Taney.
Okay.
I think that we didn't have Twitter back then, but I'm not sure that I would necessarily put this over that. I think what was interesting to me about the provocation here, besides the 5 distinct factual errors in the president's claim, is that I think a lot of people have been waiting for the Chief Justice to say anything about this president, about this administration, and were surprised and disappointed. For example, in June, when the Chief Justice wrote the majority opinion for the court in the travel ban case, and basically glided over the sort of the baggage of President Trump that was hanging over that dispute. So, I think the headline, to me at least, was finally something provoked the chief to speak out, and less so that once again the president is repeating false claims about my old stomping grounds, the Ninth Circuit.
Right, and we're going to get into those, how you've picked apart those false claims and try to set the record straight. And I also want to set the context a little more fully for how this war of words began. And to understand that, we have to rewind a little bit, because this isn't the first time the president has been said to have taken on the judiciary, particularly the federal judiciary. So we have to look at he's a provoker in general. He does try to be provocative. I think he does so very knowingly. Perhaps sometimes ignorantly, but he knows what he's doing and stirring the pot, and he's done it before. He called one federal judge biased because the judge was of Mexican descent. He called another judge on another occasion a so-called judge, and as you point out, he's not the first president to speak out against a Supreme Court ruling, but it does seem the president does so in a particularly personal way. When he does.
I mean, personal, and I would also say, and sort of in an institutionally damaging kind of way. I mean, so, folks were quick to point out that, President Obama, famously, during one of his State of the Union addresses,
Right.
had been very critical of the Supreme Court's decision in Citizens United. I have to say, I don't see that as of a piece with what President Trump is doing, because President Obama wasn't saying that the court was illegitimate. He was saying the court was wrong.
Yeah.
And I think we ought to be able to distinguish between substantive disagreements with decisions the courts are handing down and efforts to delegitimize those decisions, which I think is the more nefarious part of what's going on in the president's rhetoric.
That does seem to be the crucial difference. You're right. I mean, differences in direction or policy or results, that's why we have a three-branch system of government. If if Congress,
and it's why we have multi-judge panels.
Right, and reviews and appeals and ultimate appeals. I mean, the whole system is set up to resolve reasonable differences, maybe even unreasonable differences, when it comes to a law's legitimacy or a ruling's legitimacy. But he does question the legitimacy of the institution itself.
Yeah, and I think that's the concern. I mean, I think, the real problem that is raised by these attacks is, what is the president's end game? Is he doing this just because he likes attacking everybody who brings him bad news?
Yeah.
And as of late, he's been getting a lot of bad news from the courts? Or is this, a longer game where he's worried about his own fate potentially being up to, some of these same judges, and wants to begin to lay the groundwork and sow the seeds for, being able to question the validity of decisions that run against him more directly, when something more important to him than just his latest policy initiative is the thing that's at issue in the court.
Well, and we do need to get into some of the details of this, and we will. But just because you raised that, and that's a fascinating thought, that and many are speculating that there will be some issue or another of deep, almost existential importance to the president that may find that issue before the Supreme Court. And we also know that Justice Roberts is finding his footing now in an era where he, many believe, assumes the role of the swing justice on the court with Justice Kennedy's departure. You mentioned the travel ban opinion, and although Justice Roberts does write the majority in that case, he doesn't have a lot. If you read between the lines, and maybe not quite so needing to read between the lines at all, he doesn't really look particularly favorably on the president's out-of-court statements on the issue.
No, that's right. I mean, I think it's quite. I mean, I think the chief was trying to send a message, in that opinion. I just think that his intended recipient is not the kind of person who takes subtle messages like that.
Yeah.
And more importantly, I mean, I think the president, as he said, this is not just knee-jerk. I mean, he knows enough to know that going after the courts in general and the Chief Justice in particular is not necessarily going to put him in good stead with those people, those judges, those institutions when the time comes. He doesn't care, because it's more important to him to raise questions about legitimacy and to raise the specter that, cases he's losing not for the right reasons, than to actually take seriously that these are coordinate branches of government that are entitled to respect, even if not especially when you disagree with them.
Well, and I guess, and we should probably wrap up when we get to that point in our conversation and come back to this issue. But of course, again, this president's approach, bare-knuckled, calling people names and questioning their legitimacy. This is not something he's reserved for the judiciary. I mean, he's called into question the legitimacy of the entire electoral system in our country. He's called out senators and members of the House of Representatives and candidates, and it is something his supporters seem to like in him, but clearly has an impact.
I think that's right, and I think the difference when it comes to courts is that they're not an institution that tends to be in a position to fight back. And we wouldn't want them to.
True.
I mean, we don't want judges appending to their rulings long discussions of all of the ways in which the president said nasty things about them. So this is asymmetrical warfare, and I think that's why the Chief Justice going out of his way to address this. And, the chief doesn't do anything by accident.
Yeah.
I think was such an interesting and to me, I think, long overdue moment.
Well, and I know you're referring to Chief Justice Roberts' statement, which he issued just the day before Thanksgiving, and we'll to set up why that is so such a powerful and maybe important step that he's taken, going from some of the subtle messaging that was in the travel ban opinion to something that there's no subtlety or nuance in it whatsoever. He really sounds like he's telling President Trump to back off. But let's understand how we get there, and you can help us set the scene here. This is an asylum case that comes before a federal district court judge. Important distinction in San Francisco. And can you just give us a bit of the background, Steve, so we understand what happens afterwards?
Sure. I mean, so this is part of President Trump's new controversial policy with regard to entitlement to asylum. Under federal statutes right now, it is not a requirement that you present yourself at a port of entry. If you are a non-citizen trying to enter the U.S. and apply for asylum, you can apply for asylum even if you enter surreptitiously and are subsequently apprehended by immigration or law enforcement authorities. The president promulgated an executive order that basically says that's no longer the case and purports to deny entitlement to even apply for asylum to anyone other than those who present themselves at a port of entry. And there's an obvious and I think latent tension and inconsistency between the terms of this executive order and the relevant federal statute. So litigation was brought challenging the executive order on the ground that it's inconsistent with the relevant federal statute. A federal judge in San Francisco, Judge Tigar, issued a temporary restraining order siding with the challengers and blocking the executive order from going into effect. And actually, I should note, just yesterday, the government filed notice of its intent to appeal that decision to the Ninth Circuit. So the litigation's ongoing.
Right.
But it was that ruling by one district judge. And the temporary restraining order was not just a bar on enforcement of the executive order within the Northern District of California, where the judge sits. It was actually a nationwide TRO that had at least the effect of preventing the president from putting his new policy into effect anywhere. So,
and this you actually cite to the statute in one of the tweets that you had from the other day, and it's 8 U.S.C. United States Code Section 1158. If anybody wants to look it up or follow Steve on Twitter, and you can go back and find his tweet from the other day on this, where he lifts the part of the statute that was at issue. And that part of the statute clearly says, passed by Congress, that any alien, this governs who has authority to apply for asylum. And contrary to what the president and others have tried to suggest, any alien who presents to the United States, and then very clearly states, and you highlight it, whether or not at a designated port of arrival, and irrespective of such alien status, may apply for asylum. So this sounds like a real question of the president's authority in an executive order to declare something completely at odds with the language of a federal statute, right? That's the issue this federal judge has to deal with here.
That's right. And I think, the key is, although there are other cases where, there are charges that federal judges are adopting constitutional interpretations that are novel, right, in order to frustrate Trump policies, that's not this case. This is a run-of-the-mill conflict between an executive order and the plain language of a pretty unambiguous statute. And so, I think one of the things that is worth stressing is this is a context in which I don't think it would have mattered which judge the plaintiffs had drawn, where they had filed. The reality is it would have been pretty hard for any judge anywhere in the country, regardless of their ideological commitments, their background, whatever, to have held in this context that the executive order was allowed to trump the statute. Well, pun intended.
Well, right, and that's one of the ironies of this. And remind me if this is one of the inaccuracies or falsehoods you deal with in the series of tweets you had. But of course, it's been a big debate in what should be an appropriate judicial philosophy, whether a judge, particularly a federal judge, should legislate from the bench or should stick to the clear meaning of the text, whether the Constitution itself or a statute that's at issue. And President Trump's criticism of this ruling is that this judge was legislating, but actually it's the complete opposite, right? The judge is saying this statute is clear, and we're not going to allow the president to legislate against what is clear in the law that was already passed.
Yeah, I mean, I think one of the problems with contemporary discourse is that folks tend to just sort of assume your priors based upon what side you're on, and I think everyone can and should read the relevant statute. And I don't know how anyone could read the text you quoted from 8 U.S.C. Section 1158A1 and conclude that the statute is anything but clear that it expressly allows what this new executive order purports to foreclose. Now, maybe there's an argument that the statute is unconstitutional in constraining the president's power to promulgate this executive order. But that's not how this is. I mean, that's not where we are. That's not the argument that's being advanced. So,
well, you wouldn't do that you wouldn't make that argument in an executive order. You would file a lawsuit challenging the constitutionality of the law.
Yeah, and I guess it just seems to me that reasonable people can disagree about close cases where judges may in fact be interjecting their own policy preferences to resolve what's otherwise a toss-up. This isn't a toss-up, and so I think one of the problems I had with the president going on a temper tantrum here is this should have been low-hanging fruit, regardless of who the judge was, where the case was filed, or how it ends.
Okay, so this district court trial judge in San Francisco, the Northern District of California, issues this restraining order against the executive order President Trump tried to issue. And obviously, this was not news that the president received very, very well. And what happens next? Does he go off and tweet about this? Is that what he does?
Yeah. So I think the stories I think started running on Fox News that once again the Ninth Circuit is up to no good. The Ninth Circuit is interfering with the president's immigration priorities.
Yeah.
And far be it for the president to actually check the facts, and so the president just tweets what he sees on the news, and rails against how the Ninth Circuit is full of Obama judges who are preventing him from defending the country, and who are substituting their own judgment for his determination of what's necessary to protect the border, and that I think at one point he called the Ninth Circuit a disgrace, and a whole bunch of other choice words in a series of tweets, I think, over the course of 2 or 3 days.
And the Ninth Circuit, I'm sure most people do realize the difference we're talking about here. The Ninth Circuit is one of the federal courts of appeal in our country, and governs cases that come up through the federal trial courts in the western part of the country: California, Arizona, Nevada, Washington, and so on. It's a big, big court of appeals, but it's one of the federal courts of appeals in our system.
That's right. I mean, so there are 13 federal Article III courts of appeals, 12 geographic, and then the federal circuit, which is kind of weird. And I think one of the points that is going to matter in this discussion about, statistics and is the Ninth Circuit somehow an outlier is the Ninth Circuit is not just big, it is huge, and it is dramatically larger than any of the other federal courts of appeals by any metric. The number of states it covers, the number of cases it hears, the number of judges it has, and partly because of its size, I think one of the things that happens is it gets singled out for treatment because, by dint of its size, you get a wider array of opinions from that court. You tend to get judges who represent a greater cross spectrum of ideological views. And so it has become, I think, over time, a punching bag, especially for conservatives, who often find that the Ninth Circuit is on the wrong side of cases that they think should have come out the other way.
Well, and part of that is that the federal system that divides up the country into these federal circuits for the appeals courts, and correct me if I'm wrong, but I imagine that was set up at a time when the western part of the country wasn't as populous as it is now. So you'd have given a lot more states to the Ninth Circuit, say, than to the Third Circuit, which only has a few states, but very populous states in it, like Pennsylvania and New Jersey, or the Second Circuit, which has New York in it. But of course, over the years, population of California and the Southwest and the Upper Northwest has grown. So
yep. No, that's exactly right. And unlike the Eighth and Fifth Circuits, which at different points in American history, Congress decided to split into two, Congress has never, despite significant pressure to do so, pursued a split of the Ninth Circuit. And part of that is actually geographic, that it would be very hard to have any logical division of the Ninth Circuit that doesn't break up California. But there's actually a lot of headaches you would cause by having one state in two different circuit courts. Right? You could have a circuit split over the meaning of like California state law. That would be bizarre. And so, because I think conservatives who have, been dissatisfied with some of the Ninth Circuit's rulings have been unsuccessful in efforts to break up the court the right way through Congress. I think you've seen more of a sustained campaign to try to portray the court as a radical outlier compared to its sister circuit courts.
Well, and what is the real story there? Is the Ninth Circuit, which has been a target of criticism by conservatives over the years, is that a perception, or is there some reality to the sense among conservatives that the Ninth Circuit is often at odds with their positions?
So, I think to a degree both are true. Like, so, right, that I think as a general matter, the Ninth Circuit is left of middle as compared to the other federal courts of appeals, and that some of that's just a reflection of the overall population of the Ninth Circuit being a more left of middle. I mean, right, if we're going by, if we're assuming that the circuit courts are meant to be at least somewhat representative of the populations that they cover, that actually, I think, is largely just reflective of where the Ninth Circuit sits, right? Much in the same way that the Fifth Circuit, where I am here in Texas, tends to be pretty right of center. So I think it's certainly true, and anyone who says otherwise would be trying to sell you something, that the Ninth Circuit is friendlier to progressive theories of law, of constitutional interpretation, but not to the point where I think it's a radical outlier. Like I think what folks miss in the conversation about the Ninth Circuit is two things. One, that by dint of its size, you are inevitably going to get more outliers than you would from a smaller court. So just to put this in perspective, the Ninth Circuit has 29 active judges. The First Circuit, which is all of New England, has 6. So there are 5 times as many judges. But also, the Ninth Circuit is left of center does not mean it's any more of an outlier than the Fifth Circuit, which is Texas, Louisiana, and Mississippi, or the 11th Circuit, Alabama, Georgia, and Florida, are to the right of center.
Right.
Right. That these are parts of the country that are to the left and to the right of the overall average. And so we actually ought to expect that you're going to get a difference in jurisprudence reflecting those values and reflecting those demographics.
Well, and we have to come to the issue that the president railed against the Ninth Circuit, by the way, improperly, because it wasn't the Ninth Circuit that made the decision in the first place, and you make that
also
point. Also a factual problem. But he does go on to single out judges by the president who appointed them, which I do think sort of speaks to the partisan times we live in and the way judge appointing and judge confirming has become far more partisan in the last 20 years or so. But fill out that part of the story following the trial judge's decision, and because that sets up Chief Justice Roberts' really extraordinary Thanksgiving response and rebuke of the president.
Yeah, I think that's right. And I mean, I think you see it in media stories these days, where it's hard to read a story in almost any publication about a major court ruling that doesn't identify the president who appointed the judge, as if that is somehow supposed to tell us some meaningful piece of information about the decision. And I guess my reaction is, of course, a president who appoints a judge, we could expect the judge to be, perhaps more in line with particular views than others. I don't know why that is necessarily delegitimizing. I mean, it goes back to what we were saying before about the virtues of pluralism, right? That, ours is not a judicial system of robots. We expect to have judges. We want to have judges. There'd be no point if we didn't have judges who disagreed and who came at the same legal questions with very different priors. The question is why that should therefore impact how we view the correctness or the incorrectness of their decisions without actually looking at the analysis. And that's what drives me nuts about the example that actually set the president off in this case. Like, yes, Judge Tigar, the judge who issued this TRO, was appointed by President Obama, but this isn't a close case. This is not a case where a liberal judge, defied the plain language of a statute of the Constitution to reach a result that looks like it's a progressive policy outcome. He just enforced the statute. So the law professor in me sort of, deeply understands why we want to know who appointed the judge, but fears that we are in the process prioritizing and privileging that information over any assessment of whether we actually found the judge's reasoning convincing, which really ought to be the touchstone, it ought to be the linchpin to how we're assessing judicial decisions.
Well, and when you then consider what Chief Justice Roberts says, and he comes out with this statement and says, hey, wait a second, we don't have Obama judges and Clinton judges and Bush judges. We have an independent judiciary. And that's something we should all be thankful. That's a paraphrase, but that's essentially his message. And I mean, we know that historically that certainly is the ideal that we all hope is true about our judiciary, that no matter which president appoints the judge or justice, no matter what they did in their pre-judge life, some worked for the ACLU and some, handled pro-life cases for an abortion group. When they get on the bench, they're a judge and they handle the cases that come to them. And frankly, over history, many judges have surprised. Justice Brennan was famously described as the worst mistake President Eisenhower ever made. And there are many, many examples like that. But the ideal that Justice Roberts is expressing certainly seems like something very much worth preserving, even if in reality it's not always the case.
I think that's right. I mean, I think, it's hard to divorce this from, having just gotten through the Kavanaugh confirmation process, which I think in many ways was, took a lot of the bloom off the rose, or at least whatever was left of it. I think too often we treat the federal courts as all being the same when there's such an important difference to me between the Supreme Court and the lower federal courts.
Yeah.
The lower federal courts, a large percentage of what they do is simply apply precedent. They're not, unlike the Supreme Court, they don't have a lot of flexibility to choose which cases they hear. They don't have a lot of time to sort of sit back and, wax philosophic about deeper, longer-term visions of legal academic theories. Rather, they're managers. They're there to resolve the cases before them based on the law that they have. And I think the reality is that more often than not, the ideology of a panel is not going to matter in the federal appeals courts. The problem is that when it matters the most is in the subset of cases to which the public pays the most attention, which is the sort of the high-profile constitutional questions of first impression. And that has a way of skewing our perception of what judges do when, 95, 97, 98% of what the lower courts do is simply follow precedent that, any competent judge of any background and any partisan affiliation would apply the same way. Well,
and if they didn't do that, certainly at the trial court level, they would be reversed again and again and again by their appeals court. So they doesn't mean they always do, but that is what they're expected to do at that level. And I think
the problem, and the president, I think, is reflecting this skewed view, is that people focus on the tip of the iceberg because that's what they see.
Yeah.
And they don't appreciate that they don't even understand that they're only looking at the tip of the iceberg and that they're failing to appreciate just how much of the, work of the federal courts is happening, where we don't see it and in a way that's just not at all controversial.
Okay. So the president gets a decision from this trial judge that he doesn't like, reversing his executive order. And he goes on a Twitter rant, first of all, blaming the Ninth Circuit and saying some unpleasant, nasty things about the Ninth Circuit. Now, you've looked at this pretty carefully now, and you found a number of inaccuracies. So we do need to set the record straight on a couple of the key points here. It's because the facts do matter, obviously.
Yeah, I mean, so let's start with, I think, the most important point. So, I mean, we've already sort of highlighted two problems. One, that this decision was actually a perfectly, ho-hum opinion applying the plain text of the statute, and two, that it was a district judge, not in the Ninth Circuit. But with regard to the attack on the Ninth Circuit itself, I mean, it is commonly trotted out that the Ninth Circuit is reversed 79% of the time. And here are the two critical things about that statistic. First, it is grossly misleading because it doesn't talk about the denominator, and I'll get back to that in a second. And second, it fails to account for the fact that is right in the middle of the average for federal courts of appeals and how they fare in the Supreme Court. So let me take those in turn. So with regard to the denominator, I mean, the Supreme Court hears 65 to 75 cases a year. Ever since 1988, the court has basically had complete control over its docket. And so it's not taking every case from the lower courts. It's not even taking a small percentage of the cases from the lower courts.
It's a tiny percentage, yeah.
I mean, so just, for calendar year 2017, the Ninth Circuit decided somewhere north of 10,000 cases.
Wow.
Compared to, 65 from the Supreme Court. And of those 10,000 cases, I think the Supreme Court took, 10 or 11 of them.
From the Ninth Circuit. Yeah.
Right. So the reality is that when you look at these numbers over the last 5 terms, two things are true. First, the Ninth Circuit is only the fourth most reversed appeals court if you go by percentage. And second, if you actually account for every single decision the Ninth Circuit hands down, the Supreme Court overall reverses less than 0.1% of them.
Wow.
So, right there off the bat, we have a couple of important contextual points. Now, one response to that is, but it's still reversed the most in terms of total number of reversals. And that's true. Over the last 5 terms, the Ninth Circuit has been reversed 48 times out of 60 cases total the Supreme Court has taken from the Ninth Circuit. But it also has been affirmed the most times. Right. That's a reflection of the fact that it's the largest appeals court, and it generates the most interest as a result.
Well, and the other part that the president goes after the Ninth Circuit on, suggesting that this is all about partisanship, that it's all about the Ninth Circuit being that liberal Obama court that's just ruling against me at every turn. That's really the subtext to this attack. If you look at the facts about the makeup of the Ninth Circuit, you see that it's not what the president suggests it is at all, right? You looked at the numbers on the court and who appointed the judges on that court.
Yes, I mean, I mentioned a little bit earlier, there are 29 judgeships. That doesn't mean there are 29 judges, actually more, because there are a number of so-called senior judges, that is, judges who are, on reduced duty. And President Trump has, I think right now, 6 nominations pending to the Ninth Circuit. Assuming they're all confirmed, which I think is a pretty safe assumption, given how the Senate is looking for, January 3rd, where we'll end up with is, 16 Democratic appointees on the Ninth Circuit, 12 Republicans, and 1 more vacancy. So if President Trump fills that vacancy, it'll be 16 to 13. By contrast, the D.C. Circuit, which folks tend to talk about as the most powerful of the federal appeals courts, and certainly the most important, as of today has 7 Democratic appointees and 3 Republican appointees. So, the problem, I think, is that, yes, the president loses a bunch of these high-profile cases in the Ninth Circuit, but that's not necessarily a reflection of the Ninth Circuit being an outlier, as much as perhaps these policies being legally problematic.
So putting this into, stepping back from the details and trying to understand what's going on here and why is he doing this? One way of looking at it is, as you say, that this, whether intended or not, these attacks, verbal attacks, Twitter attacks, things that he says in front of, his supporters at a rally, that these do tend to destabilize and delegitimize the institutions of our government. But one of the things that I think my own sense is that conservatives, that Republicans generally have rested on in sticking with President Trump and supporting him, not only voting for him, but also continuing to support him in spite of things that perhaps they don't like, say his Twitter style and other things too, is his role in putting judges on the bench. Justice Kavanaugh and Justice Gorsuch before him, I think, are seen by many conservatives as, two of the great achievements, maybe the capping achievement or crowning achievement of a conservative changeover in the federal bench and particularly in the Supreme Court. So is part of what could be behind this speaking directly to the people through Twitter on this issue and the way he's doing it be a way of his saying, hey, stick with me. I will continue to appoint judges that you all know we should have on our bench?
I guess, although I have to say, I do think that there's a bit of a discordance between, those who are, biting their tongues and sitting on their hands at all the things they don't like from this president because they like the judges they're getting,
right,
and abiding these attacks on the judiciary. Because what's the point of getting these judges who you think are going to, rule the way you want and are going to apply and interpret the law the way that you think it ought to be applied and interpreted if the judiciary is going to be delegitimized in the eyes of the people? I guess I've never quite understood how that's a straight line. I think the larger problem is that I think the president understands that there are more losses ahead of him. And so the more he can do to basically, create this knee-jerk reaction where someone sees that the president lost, looks to see which court it was, and says, oh, the Ninth Circuit, that doesn't mean anything.
Yeah.
Right? I think the more he's achieving his goal. And that's unfortunate because, the Ninth Circuit is a federal appeals court staffed by judges who are just as serious about their oath to the Constitution as judges in the other courts. The president's losses, I have to say, have not been confined to the Ninth Circuit. I mean, there's, major litigation right now in which the president has been on the wrong side in the federal appeals court in New York, in the federal appeals court in Richmond, Virginia, in the D.C. Circuit. And so, I think the attacks on the Ninth Circuit are just this darker, deeper, playing to the most base, biases and prejudices of his base. In ways that I would have thought those who are totally on board with his judicial confirmation project should actually be worried about.
And you brought up earlier, Steve, the point that the president may find himself and his own fate in the hands of the federal court. There's plenty of examples of this already, and you mentioned some of them. There's also the emoluments case in the district court, I think in Maryland. That's not going very well for the president right now. But whether it's one of those or some issue arising out of the Russian investigation of Special Counsel Mueller, it may end up in the federal court and ultimately in the Supreme Court, which brings us back to Chief Justice Roberts and the statement that he felt compelled to come out with. And if there's one, even Justice Gorsuch didn't like it when the president was seen to be making some statements against the federal judiciary in a general and very political sense. So, this is, of course, highly speculating, but can you see anything in or interpret Chief Justice Roberts' actions here? Very extraordinary to come out in the way he did and as directly as he did and forcefully, and what that may suggest about how these issues filter up to the Supreme Court and may affect how they handle issues in the future.
And I think we ought not to sort of jump to conclusions, based upon one answer to one question that was put to the Chief Justice by a reporter. I think the devil's going to be in the details, or put another way, the proof is going to be in the pudding, where, the question's going to be whether the Chief Justice, does something to suggest that he's troubled, whether this is going to affect how he looks at any of these cases, whether he's going to be less deferential to the president, whether, his institutional tendencies are going to maybe win out over his more conservative ideological beliefs in some of these cases. And I think a good bellwether for that is, there are all these pending applications from the Solicitor General for extraordinary or emergency relief from the Supreme Court, where the SG is trying to jump over lower courts in the census litigation, which is in New York, in the military transgender ban cases, of which there are 3 all over the country, in the Juliana climate change case from Oregon. And, to date, the court has basically punted on most of those. I mean, there have been a couple of dissents from Gorsuch and Thomas and one that Alito joined. But what's been interesting so far is that none of the government's requests have been granted in full, largely because the Chief Justice and Justice Kavanaugh haven't been voting in favor of them.
Interesting.
And I think the question is going to be whether that continues and whether at some point we see some kind of not just, negative votes from the Chief Justice and perhaps even Justice Kavanaugh, but a statement that, the federal courts are operating just fine, that there's no reason for this administration to believe it can't get a fair shake in the lower courts first and to follow regular order if and when they lose. And I think that would be to me, I think that won't be directed to the president, it would be directed to the Solicitor General, but I think it would be a far more meaningful public statement from the Chief Justice, asserting the institutional prerogative of the court. So
these are cases, and that's a fascinating point. These are cases where, really, if we translate this into real lay speak, it's almost like the president and the Justice Department, through the Solicitor General, are going directly to the Supreme Court as if to say, hey, we know you're our friends over there in the Supreme Court. Help us out with this issue so we don't have to deal with it down in one of the courts below.
Well, and hey, Supreme Court, this district judge is being mean to us.
Yeah, right.
Usually we go to the circuit court, but we also think the circuit court's going to be mean to us. So why don't you just spare us all the trouble? Because after all, we're the executive branch.
Right.
And, what's remarkable is there are more of these applications already in the first, 22 months of the Trump presidency than in the two-term presidencies that preceded him combined. And I guess, there has to come a point where one of two things is true. Either there is some deep, great conspiracy on the part of all of these independent Article III federal judges to screw President Trump, or this is unusually and unjustifiably aggressive behavior from the Solicitor General that someone on the court ought to say something about.
Well, beyond just saying no, as when they come to them with these petitions, right?
Right, because I think, and part of this, and I think this is, a point that's less about the president and more about the Justice Department. But the Solicitor General among I think any litigant who appears before the Supreme Court has institutional both credibility and responsibility vis-a-vis the justices, and only so much capital that we want the Solicitor General to be able to spend in those cases where there really is some gravity behind the request for emergency or extraordinary relief. My concern, wholly apart from the merits of any of these individual disputes, is that we're heading toward a boy who cried wolf problem, where the Solicitor General asks for this kind of unusual relief so often that the court stops giving special consideration and special deference to the government's position, as compared to those of regular, good old private parties.
Wow. Fascinating. Well, we'll keep an eye on that as well. Steve Vladek of the University of Texas Law School, thank you so much. This has been a great conversation on really extraordinary and developing battle between the president and the federal courts. Thanks so much for being on the program.
Always a pleasure.
Thanks.